Okay, so now we are going to look at Lively's opposition to defendant's motion, limine number 9, in which so Wayfarer want to preclude the evidence that relates to Bryan Freedman for good reason, right? I mean, honestly, at this point, hands up if you are sick of hearing Lively try to drag Freedman for doing his fucking job. I'm beyond it, especially after all the crap that you've heard from her attorneys about Freedman, about the Wayfarer defenders. Now, you know, has Friedman other moments where he's probably come close to crossing a line with some of the things he said? Yes, I do actually think so. But has he done a fantastic job of turning the public, narrative around? Yes, actually, I do not think that even with all the evidence that proves that Lively has lied through her fucking ass, I still think that the public support for Baldoni and for Wayfarer generally would not be as strong as it is right now had it not been expressly thanks to Bryan Freedman. But and I find this almost I find it almost unprofessional of Lively's counsel to even be trying to make the argument that you know Friedman has done anything untoward, right? And we're in a situation where they've been complete shitheads towards him from the start, even when he asked for an extension of time right at the very start because he'd lost his home, and they were like, no. But thankfully, the judge saw some sense and gave him the extension. Since then, they've been abusing his words to leverage and get their own way, especially around Lively's deposition. They dumped an entire 400-page filing from the Vin Diesel lawsuit, where it was all to make Friedman look bad. Even though Friedman was actually exonerated for that. And they filed Rule 11, filed Rule 11 sanctions, trying to say, well, his statements, blah, blah, blah. Judge said no on the basis of Friedman's statements. He did give the sanctions, but it was for something completely unrelated, and it was nothing to do with anything Friedman said. They have subpoenaed him and his law firm, right? And, that doesn't feel good. And that's absolutely fucking wild as well. To be a subpoenaing, an attorney to be subpoenaing the opposition's attorney whilst in active litigation, that was the craziest thing I've ever seen, ever, in my life, in my entire time in working in law. I have never seen someone do that to another attorney, to the opposing counsel, no less, right? And I saw it as an intimidation strategy, because that's what those subpoenas, they were all used for intimidation. Same with the content creators. It was all for silence and intimidation. And if we examine what's happened since all of these, false allegations and kind of threats have all been made against Friedman, we hear very little now from him. You've got Ellen has kind of stepped in largely to deal with most of the filings. They brought on, other law firms as well. And Friedman has kind of not backed out. He's still very much there, but he's saying a lot less, right? So in that sense, it's effectively worked. And I don't think that should have happened. I mean, they targeted him over. I think they set him up with the whole Taylor. I'm sorry, I will stand on this, right? I think that was an entire setup with Taylor Swift, and getting him to kind of file things that they could then point to and go, oh my god, they trying to get the public to go nuts and so da 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 da, and then getting the letter stricken, Friedman's letter stricken, and then also his affidavit as well. And I will stand by this for the rest of my life, that there is absolutely no way that Bryan Freedman would have filed an affidavit stating that he had information, he'd been told information, had he not fully believed it and been told that. And then I look at the way he was messed about, right, by Taylor Swift, and it was, over the initial subpoena for the documents, right, which they then challenged in DC and filed a motion to quash against. But then also the deposition subpoena as well, where she messed about with that as well and just basically, managed to wriggle out of it. So then we never really got any information from her. I don't believe that. I think Freedman was set up. And I think it was all designed to get Judge Lyman to be pissed off, which he did. And I do think Lively's still friends with Taylor Swift. I do. Because I think Taylor Swift is just as bad as Lively. There, I said it. So, and obviously we've had a lot go on, with all of that. Then he's been accused of being part of the retaliation campaign against her, which I just don't see it at all. I do not see it. And it's irrelevant, like, what happened, whatever's gone on with him, Melissa Nathan, and the whole Amanda Ghost case. I'm not really following that, so I'm not overly interested, because that's not relevant to what's going on over there. Is not relevant to what's going on over here, and it doesn't prove the case. But I think it is coincident. I think it's just a coincidence, because they're trying to link players. So obviously what you've got here, if you look at the Amanda Ghost case against Rebel Wilson, you look at the Lively case against Wayfarer, you have got Camille Vasquez represented Johnny Depp, who was also represented by Melissa Nathan. Camille Vasquez is Amanda Ghost's attorney. But Melissa Nathan is represented Rebel Wilson, who was Amanda Ghost's adversary. Freedman also used to represent Rebel Wilson. He now represents Wayfarer. Melissa Nathan is also accused of being part of the smear campaign and representing Wayfarer, but she's accused of being part of the smear campaign against Lively. And it's just all these 6 degrees of separation, right? But the thing is, right, is they all work in close proximity to each other. And the reputations are, some of the top in their professions, in their fields, right? Bryan Freedman is one of the top entertainment lawyers, right? So the fact that he has represented Rebel Wilson, Justin Baldoni, does not surprise me. He has represented other people like Megyn Kelly, like Perez Hilton, Travis Flores, right? So there's his reputation is second to none, and he's the attorney that you would want if you were in the entertainment industry. Melissa Nathan is also incredibly good and very well known, very successful at crisis PR. She's represented Johnny Depp. The fact that there are crossovers means nothing, right? Because that happens when you are all in the same location. And these people serve Hollywood, so of course there are going to be overlaps, right? There are going to be overlaps. It's like Gottlieb has gone before Judge Lyman on several cases, right? Because of where he lives and where he practices. So you get to know people. Gottlieb probably won't know Freedman. I don't think he ever has gone before him. Why? Because they're on complete opposite sides of America. So, and except for cases where, like in Lively, where the attorneys come from another area of America to, in this case, New York, pro hac vice, then they're not really going to, encounter each other. I feel like Freedman has had a really unfair I don't even know what word to use, to be honest. I'm trying to think of a word strong enough. But I think, he's been smeared by Lively in this case, right? And the fact that there's still, even though the defamation claim, which was about his statements, has been dismissed, and even though Judge Lyman said, well, look, in the Rule 11 sanctions decision, Judge Lyman did say, well, he's defending his client, which he's allowed to do. Lively is still trying to, basically bring this in to, say to the jury, look, all these people were fucking awful. And it's just another person who, in my opinion, is rather irrelevant to this. Let's read. Sorry, I gave quite a bit then of my own thoughts, but I really feel strongly like, as a lawyer myself, I feel like, if I was being paid to do my job and then I had some idiot trying to tarnish and trash my reputation and everything I'd worked for and built for simply doing my job because they were manipulating their case and they had nothing else, then I would be quite pissed off. And I am pissed off for Bryan Freedman. I feel quite strongly about this. And I am annoyed with Lyman for letting it even go this far, right? Because it's blatantly obvious that, the man is just trying to do his job. Okay, defendants attempt to preclude in a single concluding sentence without any argument or citation to authority any mention of Bryan Freedman. The court should reject that argument, not just because it lacks any supporting authority or argument, or because it fails to specify the evidence it seeks to exclude, but also because it would implicate a significant amount of evidence documenting the defendant's retaliation campaign, separate and apart from Freedman's voluminous media appearances. For example, as the court referenced in its summary judgment order, one important piece of evidence reflecting steps to harm Lively's reputation was the group chat that Freedman started amongst his colleagues, clients, and influencer Sage Steele to discuss how to use Steele to create a video that can go viral with the appearance of being organic. Freedman appears elsewhere as well, including an admission by Melissa Nathan that he attempted to intimidate Jenny Slate from participating in Lively's case. Did he? How? Communications with media outlets and social media personalities designed to procure negative coverage of Lively and even threatening media outlets with patently frivolous lawsuits if they did not bow to his demands. Freedman's apparent regrets regarding his own words and conduct do not provide a basis to exclude demonstrably relevant evidence. Defendant's main objection to Freedman's media statements relies on the false promise that they are relevant only to Lively's defamation claim. But Freedman's statements to the media not only are directly relevant to the retaliation, they also are part of the retaliatory campaign. In its order denying summary judgment as to Lively's retaliation claim under FEHA, the court explained that there comes a point where the accused stops simply defending him or herself and starts taking action that a reasonable jury could view as retaliation, and provided examples of key messaging that crosses the line. They include suggesting that Lively had a less than favourable reputation in the industry and that Lively made marketing missteps. I mean, she did make marketing missteps. As Lively has consistently alleged, defendants retained Freedman specifically because of his reputation for being willing to bury his client's opponents. Meanwhile, Sauritz vowed to use all of his resources if Lively crossed the line, and he had lawyers ready to go. Yeah, but I'm pretty sure that wasn't Freedman. I think they were talking about, they were considering, was it Marty Singer? Sure, they were considering someone else, another attorney at that point. It wasn't Freedman. Or Melissa Nathan had put Freedman's name into the hat, but along with other people. Like, they weren't settled. They weren't ready to go. Sure enough, after Lively filed a CRD complaint, an act unquestionably protected by FIHA, Freedman promised to sue anyone associated with Lively's CRD complaint into oblivion. That's been so taken out of context. Defendant's retaliatory lawsuit followed, and channeling further retaliatory messaging through counsel was part of the strategy to capitalize on its public impact. Freedman's colleagues recommended that defendants take advantage of the litigation privilege to launder more retaliatory statements into the public. Freedman repeated those same key messaging points in his statements to the media on behalf of his clients, including by stating, Lively filed the CRD complaint as a desperate attempt to fix her negative reputation. She filed this lawsuit because she quite simply could not accept that the public had organically seen through her facade, and that Lively made threats in order to be in control of marketing the movie. I mean, all of this is true. This is all true. As discussed above in Lively's opposition to defendant's motion in limine number 5, Freedman's statements trumpeted defendant's narrative of Lively to the public, purportedly based on defendant's allegations in their retaliatory lawsuit that the court later concluded largely was not just meritless, but objectively baseless. And as discussed below in Lively's opposition to defendant's motion in limine number 16, those statements retain independent relevance for purposes of measuring damages attributable to defendant's retaliatory conduct. Whether Freedman's statements meet the element of defamation or are subject to any privilege is thus irrelevant. The statements are directly relevant to Lively's surviving retaliation claim. Defendant's Rule 403 argument that the jury will independently believe that defamation and defamation damages are still issues, which I agree with, by the way, is far too remote to justify their remedy. It presumes both that the jury cannot follow its instructions and that the jury would have followed the case details sufficiently closely to understand that there was once a defamation claim, but no longer. If, arguendo, there exists that concern, the proper recourse is not excluding relevant information, but rather asking jurors via voir dire whether they have such knowledge, and if so, if it would impede their ability to evaluate fairly the claims presented to them. Okay. I mean, I'm strongly of the opinion, personally, that Freedman's statement should, and anything about Freedman should not be dragged into this. And that's that. I don't know how Lyman's going to view that. Okay, so motion limine number 10 is the next video, and that's to preclude evidence and argument concerning retaliation in anticipation of future protected activity. So I will see you there.